Good morning, good afternoon, and good evening, everyone. We want to welcome you once again to the inaugural webinar on the state of digital rights in West Africa by our organization. We want to deeply apologize for the technical glitches that has occurred so far, and we want to appreciate your staying with us till this particular time. On that note, I will be calling on to hear the goodwill message to be delivered. If the ASF country director is available, he takes the floor. In the absence of the country director of ASF Nigeria, we have an alternative. However, again, I repeat, if the country director of ASF Nigeria is on the floor, kindly unmute yourself.
I've already unmuted Mr. Kimbo. Thank you very much.
Over to you, man. Thank you so much.
All right, thank you so much, Mr. Kimbo. Good morning, everyone. Good afternoon, good evening. And that's on the assumption that we have persons who are joining us for this webinar beyond the West African region, because otherwise we are more or less in the same time zone. So it is my pleasure to welcome you all to this very epoch-making event. It's the first of its kind, which we hope would birth progress, intensive progress in regards to promotion of digital rights in our sub-region. And it is the launch. What we have today is really the unveiling and the launch of the West African Digital Rights Defenders Coalition. I believe that the conveners would speak are going to speak more about the coalition, but we have this opportunity to unveil it to not just members of the coalition, but also those we hope would be interested in joining the coalition after today's engagement, and those who are willing, of course, to support the work of the coalition within the sub-region, but also beyond the sub-region. And we know that a lot is going on with regards to digital technologies in the world, but particularly our conversation today, we're going to be looking at the West African region. This is particularly important that we narrow down our conversations to what affects us uniquely, because while we argue that in terms of technological advancements that have and how it affects human rights, it is global, we agree, but then we have peculiarities within our region, that's a sub-region that we would want to focus on. And by this, for example, I'm sorry, I don't know what happened to my camera, but I would be talking about the issue of access to technology, which may not necessarily, if this conversation were to happen in Europe, it may not be the case. And talking about that, the beginning, I did not do a proper introduction of myself. I will do that, and then I will continue with my remarks. My name is Angela Uwandu Uzoma Iwuchukwu. I am the country director of Avocats Sans Frontières France, Lawyers Without Borders France, and I'm joining you from Nigeria, Abuja, Nigeria, where we coordinate our activities from. And we are very happy to be joining a host of other actors who are, working very resiliently to promote digital rights in our sub-region. And for this, we believe that this coalition is coming at a very important time where we can coordinate to look at issues around access to technology and how it impacts human rights. And while in other regions, as I was mentioning earlier, for example, Europe, that may not necessarily be a challenge in terms of having the internet penetrate underserved areas, but this is one of the key issues that in our region we have to ensure that no one is left behind, because before we can begin to talk about issues around freedom of expression online, data privacy, first of all, we need to ensure that our communities are are actually connected. We have the infrastructure, we're able to get them online to be able to take advantage of the enormous opportunities created by technology. And we, having said that, we acknowledge that technology does present and has presented new ways for us to enjoy our human rights on the digital sphere. However, we also know that technology is being used by state actors, non-state actors to actually infringe upon our rights. And by this, we're looking at instances across how governments have been responding to citizens taking on digital platforms to demand accountability, good governance, to organize themselves in terms of digital assembly, and then translating that movement to real-time peaceful assemblies to demand for good governance. And we have seen a lot of censorship. We have seen surveillance of human rights defenders across our sub-region. And we know that technology is being deployed for against human rights defenders, journalists inclusive. So, but nevertheless, we have to make the best use of opportunities that are available to us. And that is why I am very, very happy with the lineup of speakers that we have today, and also the topical issues that have been selected for this webinar. So we are going to be looking at how issues around freedom of information, access, data privacy, strategic litigation can be deployed in a better way to promote digital rights in our sub-region. On our own part, ASF France, we are working with indigenous organizations in Nigeria and also in other parts of the sub-region to promote digital rights. And we have the e-rights. Okay, someone is asking if I'm speaking in English or not. Yes, I'm speaking in English. So we have the e-rights project, which aims at promoting digital rights in Nigeria. And we are trying to coordinate, have some stakeholder coordination as well to ensure that we're collectively able to speak with one voice. Well, one of the greatest opportunities that this coalition presents to all of us, and I hope we do take good advantage of it, is that we are able to take advantage of the expertise that exists across West African region with regards to digital rights. So we hope that this will help us coordinate our efforts better, manage our resources better, and be able to promote digital rights in our sub-region. And with this, I believe that the speakers, we have a great lineup of speakers. We have Naro already, who's with us, and Naro is going to be speaking. I'm not taking over the job of the moderator, by the way, but I'm looking forward to hearing about the rules of internet shutdowns in West Africa. We recently had protests in Nigeria, and we observed throttling of the internet throughout the protest duration. And so it is one of the topical issues that I'm keen to see how we can coordinate efforts. And this is and that's why this coalition is so important, because sometimes when it happens, we might have to depend on colleagues who are outside of our own jurisdiction in the sub-region, and that means you, who is, for example, outside of Nigeria, to be able to take action, to push back, and to state this is what is going on. Our colleagues in Nigeria have informed us, and vice versa. So there's a great, potential that we have within the sub-region, and I'm excited that today we have vetted this opportunity to be able to leverage on all this going forward. And thank you very much for having me. I'll put my details on the chat, so feel free to reach out. We are here to collaborate. Thank you very much. I will be handing over back to our moderator, Dr. Akimbo, and then we can go on to hear the speakers for today's event. Thank you so much.
Thank you so much. thank you so much for the opening goodwill message by the country director, ASF Nigeria. We noticed that we're having medias, which is good for us. Also, we understand that there are some questions being posited in the chat room. A good introduction was done by the ASF Nigeria, and we'll be going to our first session. But before we go into the first session, for the records, I'm Dr. Adebomi Adeola Akimbo, Vice President, Internet Society Nigeria chapter, and of course, fortunate to be here as the CEO founder of DNS Africa Media and Communications. The convener is in the house. We will be attending to some of your questions. Kosi, we saw your question in the chat room. We will be attending to it, but because of time constraints, we'll be going into our first session, Freedom of Expression Online in West Africa, that will be presented by the Regional Director, Article 19 West Africa, no other person body, indefatigable Alfred Bulakali. If I got that right, please unmute yourself. You have the floor, Alfred. Okay. I want to quickly confirm, Kende, do we have a representative on ground for the beginning of that session?
I think we can take now.
Okay, noted. Okay, so as directed by the convener, this is an opportunity to move, like I said, off record before, that we will be modifying the agenda. So that means we are going to our adopted session 1, which is internet shutdowns in West Africa. It will be presented by no other person than the African Policy and Advocacy Manager for Access Now. For those of us in the digital rights corridor, it will be a pleasure for us to hear the voice. For those of us who are new, I present to you Naro Omo Osage. You have the floor.
Thank you. Hello, everyone. Thank you so much for having me. It's so great to see so many faces here. My name is Naro Malsage. I'm the Africa Policy and Advocacy Manager at Access Now, as I've just been introduced. I'm based in Nigeria. I'm from Nigeria. A little bit about Access Now. Access Now is a global digital rights organization. We fight for human rights in the digital age, and one of our key areas of work is internet shutdowns. And today, I will be speaking about the Keep It On campaign, which is Access Now's campaign on internet shutdowns in West Africa. So just permit me to have my camera off for a minute while I share my screen and share my slides. Thank you. Okay, just checking. Can everyone see my screen?
Yep, we can.
Okay, perfect. Okay, so I'll just get right into it. So I'll start off with a quick introduction. So this is an outline of our conversation for today. First, I'll start off with a quick introduction about the Keep It On campaign and the Keep It On coalition. And then I will look at understanding internet shutdowns, the impact of internet shutdowns, the definition of internet shutdowns, and then we'll take a look at some of the internet shutdowns that the campaign has recorded in West Africa between 2023 and 2024. And then finally, I will share some strategies for fighting back against internet shutdowns. And hopefully, if I manage to keep enough time, then we will have some time left for comments and questions. So first, as I mentioned, the Keep It On campaign is a global campaign. It was launched in 2016 at RightsCon Silicon Valley. RightsCon is the world's leading summit on human rights in the digital age. It's hosted by Access Now. And since 2016, the Keep It On campaign has acquired about over 300 civil society organizations, 105 countries who are members of the coalition, many of whom are on this call today. So it's very good to see faces here. The Keep It On coalition has adopted the definition of shutdowns. An internet shutdown is defined as an intentional disruption of internet or electronic communications, rendering them inaccessible or effectively unusable for a specific population or within a location, often for the purpose of exerting control over the flow of information. So this definition is what guides our work and what guides how the campaign and our partners engage on issues. So why do we fight against shutdowns, internet shutdowns? Just the simple question of why are internet shutdowns bad? Well, internet shutdowns first restrict people's ability to exercise their human rights, including the right to freedom of opinion, freedom of expression, right to freedom of assembly, and access to information. Also, during conflicts, protests, public health emergencies, intentionally disrupting internet access restricts people's access to vital life-saving information. In times of conflict, internet shutdowns make it difficult, for example, for people to navigate safe routes. It makes it difficult for people to access ambulances, emergency services in the event that they have been hurt. Internet shutdowns also make it extremely difficult for people to access and document credible information, either in times of crisis or during important events like elections. Disrupting the internet during elections, as we've seen, makes it very difficult for election observers to do their jobs. It takes away from the watchdog role of the media. People are unable to access credible information about about elections while they're going on, and so on. And finally, internet shutdowns also impacts people's livelihoods and entire economies. So for businesses, individuals, public services that rely on the digital economy, when the internet is intentionally disrupted, an internet shutdown can cost, in terms of money, billions of dollars. So to add to these reasons, based on this, international law has developed well-established principles that recognize access to the internet as a necessary precondition for, the enjoyment of human rights online and offline. The UN Human Rights Council has, it consistently affirms that the same rights that people have offline are also protectable online. So this is what the international framework for human rights law looks like. First, you have the International Covenant on Civil and Political Rights, the ICCPR, and you also have the Universal Declaration on Human Rights. So the rights to freedom of expression, freedom of association, freedom of assembly, they all find their roots in the ICCPR. And so building on that, the UN Human Rights Council has then adopted a number of resolutions on internet shutdowns, which you'll see here. The first resolution is 3212 on the promotion, protection, and enjoyment of human rights on the internet. So this was the first UN resolution that spoke directly to internet shutdowns. And since then, this language has been strengthened in various resolutions, such as Resolution 38.7, Resolution 44.12, Resolution 44.49, which specifically was passed at the height of the COVID-19 pandemic, and it recognized the importance of access to internet in navigating or combating a public health emergency, such as the COVID-19 pandemic. So coming closer home, we have the regional framework. This is more familiar to us and more relevant to us. So the first thing, they're similar to the ICCPR in a regional level. We have the African Charter on Human and People's Rights, which is also, where the foundation for recognizing the rights to freedom of assembly, freedom of information, freedom of opinion, association. That's where the foundation comes in. And based on that, the African Commission on Human and People's Rights has also adopted a number of resolutions that address internet shutdowns. There is first the resolution on the right to freedom of information and expression on the internet, 2016. And then recently, earlier this year, we also saw that the Commission adopted a resolution on internet shutdowns and elections in Africa. And then there are also a number of declarations that are relevant to internet shutdowns, like, for example, the Declaration on Principles of Freedom of Expression and Access to Information, the Guidelines on Access to Information and Elections, and the Model Law on Access to Information for Africa. So together, all these make up the foundation under international human rights law that is intended to prevent shutdowns from taking place. But as we know, this has not stopped governments from shutting down the internet. You can just see on my screen, these are the shutdowns that have been recorded in West Africa from 2023 till now. So let's take a look at these shutdowns. The first shutdown that we recorded was in Guinea in May of 2023 after civil society called for demonstrations against the military. Social media platforms, including WhatsApp, Facebook, and Telegram, were blocked. In November that year, there was a more extensive communications shutdown, and this one coincided with the banning of certain TV stations, with the jamming of radio signals. So a few months after the first shutdown in Guinea, we saw protests in Senegal following the arrest of opposition leader, and this protest triggered the blocking of social media platforms. And then 3 days later, the shutdown was extended to mobile internet access. Subsequently, when the opposition leader was rearrested the following month, we saw another wave of shutdowns in Senegal. Mobile internet access was cut for 5 days, and then a few days later, TikTok was banned. And until around February this year, TikTok was still inaccessible in Senegal, otherwise without the use of circumvention tools. The following month, we saw the elections in Gabon were colored by an internet access block as votings came to an end. And, we saw this amidst reports of voter suppression, electoral misconduct. Like I mentioned, when the internet is intentionally disrupted during elections, it's very difficult to get credible information from the ground. It's very difficult for election observers and media to do their job, to do their job in those situations. And then this year, the first shutdown that we recorded in West Africa was from Senegal, who are looking like repeat customers on this chart. So Senegal's presidential elections, which were scheduled for February 25th, there was an announcement of the intention to postpone them, and the citizens responded with protest, and the government reacted to this by shutting down the internet twice in the period of 8 days. The internet was later restored and the elections went on, but within that time, the human rights violations had already occurred. People had been denied of their right to express themselves online, right to access, credible information, even about the elections, the right to organize, and so on and so forth. We also then saw most recently on July 27th to be exact, Guinea-Bissau, the government in Guinea-Bissau shut down the internet. That's the first internet shutdown that has been recorded in Guinea-Bissau, and it was in context of pro-democracy protest. So what have we, so I mean, what we've seen here is these are the shutdowns that we've seen this year, and it's very shameful that West African governments, continue to resort to shutdowns in response to protests, as opposed to addressing the root causes of people's dissatisfaction with government performance, with the economy, and so on. And if you look at the triggers for these shutdowns, you'll see most of the shutdowns have been triggered by protests and won by elections. And it's very telling exactly when these governments choose to take away the voice of the people. So how do we, the Keep It On Coalition, Access Now, how do we fight against internet shutdowns? I'll say that the first step is in documenting and reporting on these shutdowns when they occur. So together with partners in the Keep It On Coalition, Access Now, we document verified internet shutdowns using the Shutdowns Tracker Optimization Project, STOP. So since 2016, STOP provides the most complete record that we have of the scale, variety, and severity of shutdowns around the world. We recently updated our methodology earlier this year, so you can check it out on the campaign's website. And we also publish an annual report. It's a global report that includes all the shutdowns that have been documented around the world, and there are sections on different regions. So here's what the Africa deep dive looks like, and we have just published the French version, so that's also available for people who want to read in French. So you can go there and just look at all the shutdowns that have occurred in 2023 and see the technical and political context around these violations. So another way that we fight back against shutdowns is through the Election Watch campaign. It's an initiative that identifies upcoming elections at risk of disruption. For example, in countries where there's a track record of internet shutdowns or a track record of human rights violations, or both, as they often go hand in hand. So through a strategic approach, starting from sending open letters to government authorities ahead of elections, making public statements, working with partners to carry out capacity building trainings, having dialogues with different stakeholders, etc. We engage with the different stakeholders, we engage with the authorities and urge them to keep the internet on. And one reason why this is key, I would say that in our record, 2023 has been the first year, I think, between 2022 and 2023, where we have seen the triggers, the main triggers for shutdowns in Africa move from being election related to protest. So in the past, we've also seen that election related shutdowns have been extremely high and extremely common in Africa and in West Africa as well. And this is because like election related shutdowns directly impact how people participate in democratic processes. It prevents voters from being able to access certain information, from being able to communicate with their colleagues, communicate with families, communicate with loved ones, and especially during elections where transparency and credibility are key. Internet shutdowns decrease people's perception of the transparency of elections in this context. So we have seen a number of significant just a moment. We have seen a number of significant wins while monitoring election shutdowns. I will share some of those wins, but we have seen commitment from countries such as Nigeria, such as Sierra Leone, where we have engaged with government authorities ahead of the elections. Oh, sorry, I just saw that my screen has stopped sharing. Just a moment, please. Okay, sorry, I'm confirming that you can still see my screen.
I can confirm.
Yes, we can.
Okay, thank you. Sorry about that. Yes, so as I was saying, we have seen successful we've seen successful outcomes in Nigeria and Sierra Leone ahead of elections, where the governments have committed to keeping the internet on. I mean, one thing that is key is getting these authorities to put down their commitments in writing. For example, during the elections in Nigeria, February of 2023, ahead of the elections, the coalition, we sent an open letter to the government in Nigeria, just following reports of the internet being shut down, and also following the Twitter shutdown, which had only ended a few months before the election. So we sent an open letter to the government, reminding them of their obligations under international human rights law, reminding them of the human rights violations that are associated with internet shutdowns, and urging them to keep the internet on before elections, during elections, and even after elections, as it's important throughout. And a few days later, the government responded by publishing a statement affirming that the internet will be kept on, and indeed it was kept on. So it's always a very welcome development when we see that a government indeed makes a commitment and keeps a commitment to keeping the internet open and secure during elections. We are looking at a number of elections this year. I would say for West Africa, I mean, this year has been called a super election year. And for West Africa, we will be monitoring elections in Ghana, which are scheduled for December this year. We'll be monitoring elections in Chad as well, and in Guinea-Bissau, if hopefully the elections do hold this year. So you can also check out the other countries on our 2024 elections watch there, because there are a number of other elections in Africa that we'll be monitoring as well as globally. And our Keep It On election toolkit, which is very useful for working with stakeholders, engaging with authorities, working within civil society in combating election-related shutdowns. Finally, another very important tool in the arsenal in fighting against internet shutdowns is strategic litigation. So, of course, I will not speak too much about this because the next speakers will definitely do it way more justice than I ever could. But just to mention that strategic litigations are truly an efficient tool in the shutdowns arsenal. Guinea, Togo, and Nigeria are very great examples of this. I think the most recent judgments that we've seen was in the case in Guinea. The internet was shut down in 2020 during protest, and in March and in October 2020. And in October 2023, about 2 years after the suit was filed in 2021, the ECOWAS court ruled in favor of the applicant, holding that shutdowns did constitute an unlawful interference with their rights to freedom of expression and access to information. I would say the ECOWAS court does have a commendable track record of ruling in favor of applicants, and this is something that we hope that they uphold, and we hope that other people can leverage in their fight against internet shutdowns. Yes, so thank you. I have managed to run us through as fast as I could, but thank you very much for listening. Please let me know if there are any questions. I do hope I have time for that. Thank you all.
Thank you so much. And on that note, we're supposed to entertain questions. However, because of time constraints, if Nara wouldn't mind, we move to the next session. But with the look of things, I see no questions, I see no hands up. Was beautifully delivered. Every single bit of that information sank in, probably because it's passionate. It's a passionate discussion for me. And the slides were so tight, everyone wanted a piece of the cake. So I know Nara is going to share that with us later, and we'll be able to share it to the general public to be more aware. I see a hand coming up now. Nara, should I go ahead with this hand? Oh, okay, there's a thumb up. So unmute yourself. Bankole, you have the floor.
Okay, thank you very much, Nano. Thank you, the host, for the opportunity. I see that you quite clinically established the pattern for internet shutdown by country, especially in Africa. And the source is generally from the government and of government, so to say. Are there precise defense mechanism for people that have average literacy knowledge about digital, like other than people like us that are always in the front line? Are you recommending a step down training or a national campaign for digital literacy campaign to cross no cranny of the society? And what should be the action plan, beyond the talk? What should people do when they experience internet shutdown? It has happened before during the recent protest. We have established the interconnectedness of the shutdown. The ruling class are using this as a weapon, to suppress freedom of expression. And to, allow people to galvanize together in protest or in defense against their, ruling. What should be the action point for ordinary people on the streets, knowing that this exists? How should they, going forward, assert themselves in the digital space?
Over to you now.
Yes, okay, so I'll just go ahead. Thank you for the question. I think what I would say is, so ahead of situations where we, should I use the word suspect? Ahead of situations where we anticipate internet shutdowns, something that we typically do is that we are keen to share digital security tips with, for example, ahead of the protest in Kenya, we shared digital security tips with people who were going to be attending the protest, tips on staying connected if there is a shutdown, using circumvention tools, and so on and so forth. And I think, like, specific to the question that you asked about literacy, one thing that I would say is that we also shared these tips in native languages. For the Kenya tips, we made sure that we also shared a version of the tips in Swahili, which is very relevant for the people who were going to be attending the protest, and amidst the concerns that they were having about a shutdown. In terms of training, in terms of working with partners, with organizations who are, as you mentioned, in the front lines, we certainly do carry out those trainings. We certainly support partners, work with partners who are delivering those trainings. And if there's ever any opportunity to engage with civil society, to engage with human rights defenders ahead of these events, ahead of these ahead of these shutdown triggers, such as elections, as I mentioned, and upcoming protests, for example, we're always keen to work with them and put together these digital security tips into trainings.
Great. Always on point. Thank you so much, Naro, for taking time out of no time to ensure that you give us a thorough orientation. This is a proper thorough orientation and awareness of what is happening in West Africa. And we say big thank you. As we move on, we will be calling back on you again, probably for some words of advice before we end this inaugural meeting. We still have 2 more speakers, and probably we may still end up with one. I want to confirm if Mojirayo Ogulano is available.
Article 19 team members are on the call now.
Oh, great. Okay, great. So now we go to session 2 of the day. Session 2 of the day, where we'll be talking on freedom of expression online in West Africa. Don't forget, we just finished on the issue of internet shutdowns in West Africa. So freedom of expression online in West Africa will be delivered by Article 19 West Africa Regional Director, no other person, but like I mentioned earlier, the fatigable Alfred Bulakali. You have the floor.
Thank you very much. Good morning, good afternoon, everybody. My name is Alfred Bulakali from Article 19 West Africa. I didn't prepare a formal presentation because I want this to be like a discussion of all actors here. I will just present some lines to open this discussion that I expect to be rich from all of us. When we look at freedom of expression in our region, we notice that we have a part with security concern that I can call the Sahel region, and within political crisis. And we have also where democracy is still standing, like the costs of the region. And the trends of freedom of expression can vary from one of this region to another. We have realized that in the Sahel region, where we have military coup, and I can add that to Guinea, with political crisis, the freedom of expression is under crisis. If we look at media from Burkina Faso to Niger through Mali and Guinea, we know that journalists and media are undergoing a crisis period with a lot of threats to the freedom of media, going from arrest of journalists, threats to them, physical assaults, and even closure of media. We recently experienced closure of about 5 media in Guinea, added to threats to journalists and send journalists to exile in Burkina Faso. We have foreign medias in Mali and Burkina Faso closed or suspended. The recent case being the French LCI television suspension by the regulatory body in media in Mali last week. So media under crisis, I will say, in this region. Looking now at the freedom of assembly, we know that it's simply very difficult, even impossible, to free assembly in Mali, Burkina Faso, and Niger, especially if it's not to support the political leaders in place. Any form of dissent, assembly is simply banned, and those trying either arrested or physically assaulted. We know that political space is closed, very difficult for opposition political parties to exercise their activities in the country or to express their opinions when they are not to support the military government. So that's the situation. Now on the coast, when we can say democracy is still undergoing, starting from here in Senegal, we know that we are coming from a very difficult period. The last 3 years with a lot of pressure on media and journalists, with pressure on political dissent. With the new authorities, we are expecting a kind of openness. I won't say that everything is quite good now. We are expecting so much. There are still a lot of things to do. You recently followed the media under pressure because of fiscality. Of course, it's the right for the government to recover fiscal duties from the press and other business company and fiscal holders. But again, that should not affect the right to information and the possibility for media themselves to operate. We had a lot of pressure on media in Togo in the frame of election, and wherever being in these countries with crisis or with countries that still undergoing democracy process, we know that election is always a very difficult period for freedom of media, freedom of assembly, and freedom of expression itself. So we published early, 2 months ago, the expression report, and we
Can I confirm if it's from our end?
You are audible, but the speaker is not anymore.
Okay, thank you.
Can you still catch me?
Yeah, I think we
Now
got
we
you back.
can.
Yeah, I was saying that Article 19 published the expression report that takes key numbers of indicators on the status of freedom of expression in the world. And in Africa, we saw that for Senegal, Burkina Faso, the Central African Republic, They were among the rare countries in the world where we went from restrictive environment to very restrictive, even closed environment coming to freedom of expression. I will say that the democratic crisis in West Africa goes together with the crisis of freedom of expression in the respective countries, with more accent in the Sahel region, countries under military government, but not better neither on the coast where we still have democratic processes alive. And examples are Togo, are Nigeria, where we had a very repressed protests this month and last month, and yes, others. From beyond the fact itself, the repressive environment, we have the legal environment that is not favorable to freedom expression, being the laws and the policies governing the freedom of assembly, the freedom of media, with criminalization of press libels and defamation, criminalization of false news and disinformation, and use of digital laws to bring back criminalization of offenses that were either decriminalized in penal codes or in press codes. So a legal environment that is not favorable, that is restrictive, crisis in the Sahel region, not better on the coast where democracy is. When we look at the three freedoms associated with freedom of expression, we'll say the region is under democratic tension crisis, and so is for civic space, political space, expression space. So this is just giving the board of the region and opening the discussion among stakeholders on this meeting. Expect to learn from your own experience in the respective countries. And of course, my colleague Janet, you can share the link to the Freedom of Expression report that we published 2 months ago. Thank you very much, colleagues. Ready to have questions and comments. Thank you.
Thank you so much for that concise delivery. And I believe the link has been shared by Janet for the expression, for the report in question, www.globalexpressionreport.org. I think we should all, copy it and, go ahead and, take a look at it and be able to make use of it. I see no hands up at the moment. And I can vouch that we have Mojirayo Ogulano in the house. So, having no hands up, that was concise. Thank you so much for your delivery as we move to session 3. Session 3 for today. And thank you. Our timing so far so good has been on point. I want to use this once again to tell those who joined us in between. This is the first of its kind, the inaugural. And we will be, of course, welcoming new leadership, country leadership today for the job ahead. Having said that, I want to welcome, my apologies, I'm trying to check if I missed anything in the room, just to be sure we're having it. Janet, I believe, is one of my co-hosts. I believe the recording is in order so that we don't miss out anything. The ground rule still remains that you mute yourself and hold on until you are recognized. And having said that, I am privileged to say we'll be going to session 3, strategic litigation on digital rights in West Africa. We seem to be having 2 presenters, but I can vouch that I have information that 1 person has arrived. So I'm going to call on the first person there and hope that the second person will join in. And as you know, in the non-governmental, non-profit platforms and industries or stakeholder engagements that we do have, it's always ladies first, which is good etiquette. I want to call on the executive director for DG Civic. Is a known individual when it comes to West African litigation issues, and of course, highly respected. It's a she, so she's also what you can call the Gender and Media Rights Advocate Digital Representative, co-chair Legal and Digital Rights ISOC Nigeria, apart from being the Executive Director of DG Civic Initiative. I present to you Mojirayo Ogunlano. Mojirayo, you have the floor.
Thank you, sir. Sorry, I was trying to unmute myself. I don't even know what was going on with my mind. Well done, sir. Good afternoon, everybody. Good afternoon. Can you hear me? Good afternoon, everybody. Can you hear me?
Loud and clear, Moji, loud and clear.
Okay, thank you, sir. Yeah, so, sir, I joined late, so I want to be guided by what I should say on this call.
My apologies, I muted myself. If you can hear me very loud and clear, you are one of the presenters on strategic litigation on digital rights in West Africa.
Okay.
So,
okay, thank you, sir. Okay, so I think one thing that, especially for people who are in the digital rights space now, one thing that we can all agree is that this stage or this space, the digital rights space, is a new space, sort of. But when I say sort of, like it's not our usual offline space where we can do face-to-face and all that. We all know that. We know that the advent of the internet has changed the legal landscape when it comes to the rights that occur on the online space. So usually, if you talk about digital rights, I want to believe that Mr. Kimbo is also aware that it is very broad. It is a very broad spectrum of different rights, different situations. In fact, if you are talking about the usual fundamental rights, you are talking about digital rights. And then if you're not talking about even in trade and investment, some certain kind of transactions, you will still be talking of digital rights, because you talk of issues like intellectual property, you talk about blockchain. And so all these, plus the issue of access to the internet, the issue of internet shutdown, then of course, press freedom, they are all very relevant, and they are all basic issues that are happening in the digital space. And so one of the best tools, for instance, when we are, okay, before I say one of the best tools, let's talk about why rights, why do we want to actually be, when we're talking about digital rights, why do we want to also add in that same category, for instance, strategic litigation? There is a fact that when you talk about rights infringements, we are talking about violations and abuse. When violations are actually, how does it, the infringement of rights that are coming from government and its institution, while abuse refer to, the infringement of rights by individuals, and in their private capacity. And so in both categories, whether government or individuals, and then we also have abuse by corporations. So when we're talking about all these, there is no doubt that it is always important that enforcement of rights should be guaranteed. There should be an opportunity to find redress when rights are infringed. And so that is where strategic litigation comes in. Now, strategic litigation in our time, or in this age, let me put it that way, has been targeted towards addressing rights infringements that are perpetrated by government and its institutions. So they are mostly targeted that way. They are mostly targeted that way because we have understood over the years that government exercise a lot of power. And not only do government exercise a lot of power, government as the government has the tendency, I think that's the appropriate word, tendency to go above and beyond the power that is allowed, whether under the laws of the constitution in their countries, or the ones in the international, the ones that they have sworn to or they are obligated to protect and fulfill and respect in the international environment. So we have situations where governments are signed on to international instruments and treaties, such as the International Covenant on Civic and Political Rights, or we are talking about the International Covenant on Economic, Social, and Cultural Rights, or we are talking about regionally the African Charter, or we can also say in the sub-region, the ECOWAS Treaty. So when governments have gone beyond the powers that they are allowed, or in situations where their institutions violate the rights of citizens, the appropriate medium that lawyers like myself have found as a tool for holding governments to account, or holding government institutions to account, is the strategic litigation. So strategic litigation is litigation that is targeted towards achieving a social change. That is my definition. So it is a litigation that is targeted towards achieving a social change. It is a kind of litigation which ordinarily should be about the litigant. Should be ordinarily, it should be about the applicant obtaining redress, or the applicant obtaining compensation or damages for the violations of their rights. However, strategic litigation has gone beyond that, because after the applicant has been able to get redress or compensation or any form of positive decision that comes from the court, because in certain circumstances we have declarative judgments, decisions from the court. So strategic litigation now goes beyond that particular individual and then addresses issues in the society, and then are applicable over generations. So it is not limited to that particular society in that time, in that time frame. So strategic litigation goes beyond the now and goes straight to the future to address issues, or to serve as a restriction for the continued or for the attempt to infringe or to violate human rights. So that is what I can use in the description of strategic litigation. So strategic litigation has been used severally by different organizations. And one of the organizations that I have represented in the court is Amnesty International. Let's say we have used strategic litigation, for instance, in the Amnesty International Togo case, where there was shutdown in Togo, and we sued the government of Togo in 2018 because of the shutdown that took place in Togo, whereby journalists could not practice their profession, whereby the society was shut down, because government felt that was a way to curtail the citizens' rights. And one of the beautiful things about strategic litigation is it gives you the opportunity or the laxity to address some kind of ills that may be foreseeable to the kind of situation on ground. So, for instance, there is no right to the internet. There is no, I don't think there is any jurisdiction in the international space that has given any right to the internet. But with a case like the Amnesty International Togo case, what we did was this. We went into the law books and we said, the Togo government has signed on to the instruments, international instruments and regional instruments that guarantees the right to freedom of expression. And so the right to freedom of expression in today's world has been, how do you put it, has been exercised not only in the offline space, but has been exercised also in the online space. And because of that fact, the online space gives every citizen the opportunity to access the internet, to express their opinions, to share and disseminate. For instance, for journalists, to share and disseminate information, then for citizens to access information. To access information. And so, in this kind of circumstance, we told the court that in this case, we have individuals whose rights have been infringed. They are unable to access information. We have a journalist who cannot even exercise and how do I say it, to carry out his profession. In this kind of sense, he cannot carry out his profession. And so you have denied that journalist his right to access, to express himself, and the right, generally the right to freedom of expression. And so when we brought this before the court, we also showed the court that we are very aware that the provisions of the of several international instruments also provides for justifiable situations where rights can be infringed. Okay. But we told them that internet shutdown.
Friday I will not be there.
Mr. Kaura Moses, mute yourself. Oh, thank you. We told them specifically, or we addressed the courts, letting the courts know that rights infringement in the forms of internet shutdown. Internet shutdown is a right infringement that cannot even be justifiable. And we brought up issues concerning the three-part test that was explained under Article 19. It is there under Article 19.3 of the ICCPR, where it says that for any restriction to the right to freedom of expression, there must be a law in place, and that law must pursue a legitimate aim. And not only that, the law must be necessary in a democratic society. And in this case, whatever measure that will be used in addressing a, how do I put it? Your justification, or whatever measure that you want to use in justifying the measure, justifying the measure and to align with your legitimate aim, it means that the measure must be proportionate to the legitimate aim itself. So if you are saying that there is a likelihood of chaos, anarchy, and doom, as Thomas Hobbes expressed way back. So he said there is chaos, anarchy, and doom. Then the court will now place your legitimate aim, for instance, that, let's place it side by side the measure that you used. And in this case, in Togo case, they shut down the internet. And we told the court that what was the worst case scenario that could have happened with people expressing themselves, sharing information, accessing information over the internet. And the government had to show that by using the internet, there was going to be a likelihood of chaos, anarchy, and doom. The government couldn't show that well. In this case, even though they tried to justify that, there was going to be a lot of crisis, it threatens the national security. The court only asked one question: do you have a law in place that addresses this, your shutting down of the internet? And the government lawyer said, no, we don't have a law in place, but we released some kind of regulation, and it was from the ministry, and the court says, no, you don't even have a law in place. Maybe if you had a law in place, maybe we could analyze further to see whether it is justifiable in the circumstance. And so even though the court didn't put this, if you had a law in place, the court was like, oh, you don't have a law in place. And so, and then the court went further to say that the internet is a platform. There's no right to the internet on its own, but the right to freedom of expression gives the laxity for how do I put it, for citizens to exercise the ability to go on the internet. So in the words of the court, it says that the right to the internet is a derivative right of the freedom of expression. So it is derivative of the freedom of expression. It is, the internet becomes a platform that gives citizens the ability to exercise their rights in the digital space. So imagine when we had that judgment, I'm just telling you the impact of strategic litigation. When we had that judgment it was delivered in 2020. That judgment traveled all over the world. Not only did it travel all over the world, it became a judgment that won an award for the significant ruling of the year 2020. Significant ruling of the year 2020, and this award was given by the Colombia Freedom of Expression. You know, that's a big institute, that's a big organization that recognized what the ECOWAS court did at that time. So that particular judgment became one and first of its kind in the world. And so I as a landmark case, it has become a particular judgment that has been relied upon subsequently in other strategic litigation cases, such as the 222 days of Twitter shutdown that happened in Nigeria. The court also based the judgment, citing this particular judgment of the Amnesty International Togo case, that you cannot just shut down Twitter because you have denied people the access to express themselves, to access information, to disseminate information over a platform. So that's a very good impact of strategic litigation. And I can even mention other cases. There was also the one of the blogger of Guinea versus the Guinea, and that's Guinea Conakry. And and it's still the same mindset that the court exercised when it was reaching its decision. So I just want to, as last word, say that strategic litigation remains the veritable tool for achieving social change, as I mentioned, and that it is here as a perfect tool for achieving digital rights, especially in this age where governments are going beyond and above their what do I call it, above their powers, and governments continue to exercise arbitrary decisions, and should this be coming up, we know that strategic litigation can be the legal mechanism that can be used to address such violations or right abuse that come from government and citizens alike. So thank you very much for listening.
Thank you so much, Mujirayo. You hit the bull in the eye. And I was busy, while I was listening, I quickly drafted the line that I posted in the chat room, where I said Article 19 is no longer just a line, but a platform ensuring the digital rights of the netizen. And I understand that our physical rights is also our digital right. The landmark decision is playing so many roles, and we hope to speak on other issues in the an organization so that Africa in general will understand its digital rights and be able to use it appropriately, understanding that we have partners and stakeholders who want to ensure that the average netizen has his digital rights uninfringed upon. And on this note, we move into the final phase of our webinar, where we call on all our country directors pro tem appointed.
Hold on.
Okay.
Don't forget Solomon Kedara.
Oh, sorry. Okay. On this point, I have to, my apologies. I was looking at time. My apologies. So I want to call on my brother. He's my brother. So he would accept my apologies so quickly. Okay. So he will also be leveraging on this particular session. Strategic litigation on digital rights in West Africa. He is co-founder, Digital Rights Lawyers Initiative. He is a well-experienced man in the field, and I present no other person than Solomon Okedara. You have the floor, sir.
Good afternoon, everyone. And of course, I'll be quite brief as much as possible. Mujira has laid some very good foundation for whatever insights I want to share right now. And I will just proceed on that. So, because I wouldn't want to duplicate some very good efforts she had made. So I will briefly touch on some areas Muji did not touch. And talking about strategic litigation, in West Africa, it's actually quite important for us to understand some key factors that actually stand strategic litigation out, particularly in the West African region. So I will touch on two issues and actually dwell on them. Then, of course, I wrap up this session. The first one is the courts. So when we are looking at strategic litigation in West Africa, which courts do we approach? Do we approach a national court? I mean, maybe a federal court in Nigeria, a court of the state in Nigeria, or we approach the ECOWAS court, which is a regional mechanism. So, but to do that, to make such a decision, then we need to consider some very important factors that will actually tell us which of the firm is actually more suitable for this strategic litigation. Then, of course, I'm also going to talk about the reliefs. How do you catch your reliefs that will actually serve the social interest? I mean, the wider interest beyond the party, who has actually litigated or in whose name the action has actually been brought before the court. So starting with the court, the very first thing is that when you are going to consider which court do I approach a national court or a regional mechanism, ECOWAS court in this situation, then we need to consider the nature of the cause of action. If we look at it, I think the learned sick Mr. Femi Falana said this, and I've echoed it a couple of times about the opportunity to do so, that Nigerian Constitution gives us a very comprehensive robust mechanism when it comes to protection of human rights. Why? Is Section 46 says that any person can approach a court, a high court within the state. Now, if his rights are being contravened, is being contravened or is likely to be contravened. Now, this actually makes a distinction between approaching a national court in Nigeria or ECOWAS court for violation of digital rights. If your digital right has been violated, yes, you can approach the ECOWAS court, strictly. But if it is being violated, if it is likely to be violated, which means it has not been violated, now you may have to have a rethink on whether you want to approach the ECOWAS court or national court. Because if you approach ECOWAS court, you stand a chance, or your matter stand a chance of being considered to be mere academic. However, the Nigerian Constitution in its Section 46 actually gives us a very good landing, or standpoint that, look, even when it is yet to be contravened, but there's a likelihood, then you can approach the court. So when you are now looking at the justiciability of the action of any digital right that has been violated or that you seek to protect, then you may consider, as it being violated, then of course I can as well immediately go to the ECOWAS court or go to the national court. But is it likely to be violated? It's not yet violated. Then I can immediately approach a national court based on provision of Section 46. However, if your digital right is yet to be violated, or digital rights of the citizens or a group or an association of journalists, are yet to be violated, but may be violated. But that likelihood of violation is rooted in law or a regulation or a code. Then over time, the ECOWAS court has demonstrated its position, its interest, and has justified its position in interrogating the legality of such a law in such a way and manner that it can violate rights. For example, October last year, we got a judgment against the Nigerian government on the issue of using the Nigeria Broadcasting Code to violate media freedom of over 200 million Nigerians by actually imposing fines and excessive sanctions on media stations across Nigeria, by which the court even went ahead to actually order the Nigerian government not only to stop using that code, but also to amend it to bring it in conformity with Nigeria's obligations under international treaty. As a matter of fact, for the first time, litigating before the court actually ordered the Nigerian government to file a report of compliance within 6 months of that judgment. So when we move from that, then we may need to consider what is the jurisprudence of the court looks like when it comes to the particular right you are actually seeking to protect, before the court. For example, if you're looking at right to internet, if you're looking at jurisprudence on you may want to consider jurisprudence of the court on the internet shutdown. I can categorically tell you that you may have to consider the ECOWAS court. The ECOWAS court over the years have actually shown that it has a robust jurisprudence and it has built it, when it comes to issues of internet shutdown or digital platforms. So I think we may have to consider that, okay, so do we stand a good advantage if you are looking at such an issue in this? What has been the pronouncement of that court over the years? For example, there are a couple of Court of Appeal and Supreme Court in Nigeria on the issue of blasphemy laws, that are being implemented and enforced in 12 northern states in Nigeria. But the striking reality, anyone litigating on such laws need to confront themselves with is that our Supreme Court have actually decided that death penalty is the sanction for blasphemy in Nigeria. And I realize that it may be quite strategic when you want to really confront, such a law, such a repressive law that impacts on digital rights, because what that means is that if I go on my Twitter handle and I say something derogatory or taken or interpreted to be derogatory against a particular religion or a prophet of that religion, then I may actually have a day in court, when it comes to blasphemy law. And if I'm convicted, I may actually have to pay with my dear life. So the point here is that what has been the position, or what does the jurisprudence of ECOWAS court looks like in that region? For me, I would rather say, look, let's approach the ECOWAS court, get the judgment from the ECOWAS court, then actually use that to mount pressure on the national court in Nigeria or in some other country as may be. Maybe in Nigeria, it's Ghana, or it's Gambia, and all of that. So that may actually be a very important consideration. Then let's quickly go to reliefs. Now, one of the things that stands out strategic litigation from the individualistic litigation, which only seeks to protect the interest or the right of the applicant or claimant, is the fact that the reliefs actually bring results that serve not only the interest of the party in whose name the action was filed, but that serves a group or the general public. For example, if my right as an individual whether as a journalist or as a lawyer or as a citizen, is violated, then perhaps I was making use of my Twitter handle, and let's say, for example, the government had issue with what I've tweeted, and I got arrested, detained, and all of that. So if I go to court to make a claim that yes, the use of digital platforms, including Twitter, is a corollary to my exercise of my right to expression, then my arrest, detention, and perhaps brutality or some other punishment either are violations of my right to expression on digital space. Then that the court should so hold, and the court should actually grant damages, against the respondent, which could be the federal government, in this system. Now that will only serve me. Now it will not serve some other persons that whose right may be violated in the future. But if what I do is, okay, I looked at it that what law did they rely on to arrest me, detain me, and perhaps prosecute me? And I found that, oh, it's actually the Cybercrime Act. Oh, it's the defamation law. Oh, it's some other law somewhere. So one of the best things to do is when litigating strategically, I must ensure that I go to the root of the legal framework that was relied on to violate my right. For example, let's say Section 24 of the Cybercrime Act as amended. So I may need to actually challenge that provision beyond the challenge of my arrest, beyond the challenge of my detention. I must also challenge the fact that there is such a law that is used. The moment, and one of my release may be that the court should declare that that law is in contravention of extant provisions of the Constitution or contravention of extant provisions of international treaties to which my country is a party to. And the moment the court makes such a declaration, then that has not only served my purpose, that has not only given me the freedom, that has not only protected my interest, it has protected the interest of over 200 million Nigerians, for future occurrences. What that means is that in the future, nobody can come and arrest my neighbor, arrest my cousin, arrest my partner, arrest my colleagues, based on that particular law any longer. Why? Because that law was strategically litigated against, and we got favorable judgment. If I have actually gotten favorable judgment only on the arrest, detention, and compensation was paid, then of course I have left every one of over 200 million of us to actually sort themselves. And I think that may actually be quite individualistic, and in a way may not actually serve the purpose, of the general society. Now, oftentimes when I consider strategic litigation, on a final note, I always remember the quotes attributed to the German priest, Martin Müller. He said, "They came for the Jews. I didn't speak up because I wasn't a Jew. They came for trade unionists. I didn't speak up because I wasn't a trade unionist. They came for socialists. I didn't speak up because I wasn't one. And then they came for me, and there was no one left to speak up for me." So I think for me, this is actually the foundation of strategic litigation. And we need to consider it when we see a need to make a lasting change in the society. To go beyond, Solomon is arrested, he goes to court. Mujiraja is arrested, she goes to court. Can someone just go to court and address the legal framework, address the policy, address whatever it is that our oppressor, is relying on to actually oppress us and contravene our rights? At this point, I think I'm going to stop here. If there are one or two questions, I would love to attend to them. Thank you.
If there are one or two questions, he would love to attend to them. I love the it's a popular quote. However, It's always new anytime it is stated by digital rights activists who knows his onion. If they come for others and we keep quiet, what good are we doing? Digital rights issues, let me just say rights issues before it now comes to digital rights issues. So in the absence of any questions, I see no hands up. I see no comments.
I would love to ask a question though.
Okay.
I was looking for the palm recognition, but I can't find it here.
Okay,
good afternoon and greetings to everybody. Okay. I love the conversation so far. We have emphasized the significance of digital rights. May I ask, when we talk about digital rights, are we also navigating the very crucial space of digital accessibility, especially in Africa, where a situation you have those who have access to the internet and those who don't have access to the internet? Is this also considered a very significant conversation in how every other part that don't have the infrastructure, don't have the means, the connections, how is this also infused into the bigger picture of the right of every person in the context of when you shut down, you're denying access, vis-a-vis you don't have an infrastructure in your environment, rural setting or wherever kind of setting it is, you can't even have access. So you are also denied as it is. You are blocked away from every other people. So is this a conversation too that is infused in the entirety when we talk about digital rights as well?
Okay, so if Okedara wants to take that question, I'm going to give you 3 minutes. My apologies. And
I'm done. Anyone can answer with regards to that, please. Thank you.
Yeah, if Naro wants to intervene, Naro too has 3 minutes because we are talking about digital rights and he is asking questions of if access comes into the perspective or the horizon where we're talking this. So, okay, Dara, you have the floor first.
Brilliant. I consider the question a very brilliant one. I must say, so one of the things we need to understand is that if I do not have access to express myself, on digital spaces or digital media, then of course I shouldn't even be talking about any digital rights whatsoever. Now, in the case of and Union of and State of Kerala in India, it's actually an India case, and it's a case I worked on for Columbia University for our Global Freedom of Expression project. And in that case, there were pupils in a school in the state of Kerala. And it just happened that the school came up with some policies and some porters, these were high school students, right? And some porters began to enforce some of the policies arbitrarily. So it happened that on a particular day, a particular porter seized
we lost today, sir.
Personally, the male students were on that occasion. So this particular female student felt so bad. Can you hear me, please? Hello?
We can hear you now.
Yes,
we can hear you.
Go ahead.
Okay, so this particular female student felt discriminated against, felt something was wrong, and approached her parents. The parents actually decided to go to court and, of course, to challenge the violation of her right to access the internet. For the first time in India, and for the first time anywhere on our planet, the right to access the internet was declared a fundamental human right in the case of R.K. Shirin and State of Kerala. The court held that the school's management, through the portal, to have the decision to have seized a phone, which the student was using to access the internet, to conduct our assignment, to conduct some other activities as a citizen, as a human being, was actually a violation of her right to expression. Because when she was stopped or prevented from accessing the internet, her right, her digital right to access the internet was violated, and the court considered that right was just a right, like she could stand, amongst her colleagues within the school and freely express herself as a student that she was, as a human being that she was. And for the first time, the right to internet was considered to be a fundamental human right in India. So what am I saying with this case? What I'm saying here is this: if we cannot actually enforce, if we cannot advocate for right to access the internet, including right to have access to internet accessible to everyone, regardless of their earnings in the society, then we cannot be serious to be talking about digital right. So for me, I think I agree with you that until we make access to internet, whether by affordability or by accessibility in some other ways for all citizens, for all persons, now not just even citizens, including residents, for all persons, then we are not serious talking about digital rights. So I agree with you. Right to access to internet is a digital right. Thank you.
Thank you so much. Does Naro have anything? 3 minutes?
Yeah, thank you. I think the only thing that I will add to that is that, as I mentioned, the UN Human Rights Council has always affirmed that the same rights people have online are protectable, have offline are protectable online, and it's also been affirmed that internet access is a necessary precondition for people to exercise their human rights. So I think that's perhaps a good foundation to look at it from. In considering, I think as one of the speakers earlier mentioned, while it's still on the horizon before we see internet access being classified as a human right, there are human rights that are already recognized, which are directly linked to internet access, which are directly linked to the ability of people being able to access the internet in order to fully enjoy those rights. So I think that's the only perspective to that I would add.
Thank you so much, Naro. And that concludes our sessions. My apologies. That concludes our sessions. We have less than 10 minutes to wrap up. For every digital right advocate right here in the room, you've heard it from the horse's mouth, or let me use the word expert's mouth or professional's mouth. And the onus is on us in West Africa to get the ball rolling. We have some suggestions on ground. We have other issues that we need to look into, which are policy issues. And based on that, we move to action words, action. And so on this note, I'm calling quickly on all members of the national focal point for each country in West Africa. If you are available on the platform, this would be a good time for you to raise your hand for recognition. Again, ground rules for record purposes. Kindly put your full name in the platform. I can see one name, one name. I will need full names. So if you have just one name, change it to full names apart from the moderator platform. Okay. So if everyone can hear me, for those of us who are national focal points, kindly raise your hand for this last session. So having said that, I want to use this opportunity to say that we hereby present to you the following members who will be supervising and directing all activities of the organization within West Africa. If it is possible for us to have a round of applause, please, you can do that with icons.
Recording in progress.
You can do that with icons, just to show that we recognize them. It's a brief moment and it's an historic moment. Thank you, Bankole, for clapping for them. We want to say we wish you all the best. And I'm saying this in capacity as a member of the organization supporting the convener and ensuring that things will go right. In the next 6 months, we will be able to deliver to West Africa something significant and historic as an organization. Having concluded this part, we say congratulations to everyone that is now a national focal point, and we call on the convener, the live wire, the man who is digitally, propelled to ensure that West Africa gets the best of digital rights issues. Of course, he's a member of the African Civil Society on Internet Governance Forum. He's also a co-chair on the working group of the Internet Society Nigerian chapter. He's also soon to become a fellow. Apart from other fellowship, he has, taken upon himself as a digital rights ambassador. I present to you our convener, one and only. I hope he's listening in. Oga Kehinde Adegboyega. You have the floor, sir.
So good afternoon. So I was not sure whether I was trying to, trying to. So thank you. This is just a time to say thank you for our partners. Want to sincerely appreciate. Within the shortest time we are able to put this together. We want to appreciate ASL Advocacy Français, especially the country director Angela. And we also want to appreciate the team from Article 19, the West African region. We've been having, even sometimes we talk, chat late into the night in our DM, trying to ensure that it comes out. I want to especially also appreciate Naro from Access Now. She has made that time available for us, and even in planning this, I want to also appreciate Mujirayo and Solomon Okeda for their expertise presentation doing this, and I'm very sure we understand that we have a lot of experts, a lot of value within the sub-region that we need to maximize. And we'll be making this recording available to us very soon. So, and I will take our time to listen back again at the presentation, even from the open remarks from the country director of ASF Nigeria and all the other presenters. Their key points, they are precise. We also try to ensure that the slides that are presented from Access Now team member, that the Africa advocacy person now will be shared with us too. So really have to appreciate everybody that participated, provided technical and all that support. Like Dr. Akiba had mentioned, the country representative will be contributing to running the affairs of the coalition. We seek your support in whatever ways you can give the coalition. We have a big mandate. We'll be reaching out to us what or the next step ahead. But like we have realized from the invitation that we sent to most of us, this coalition is targeted at driving advocacy around digital rights in the sub-region, that is West Africa. And we really commend the work of individuals and institutions that have been contributing in their own great ways in driving advocacy around digital rights in the region. This is also we trying to come together to contribute to that effort, and we hope that we continue to get this support in achieving this. And that being said, we want to appreciate you for your time once again. And I remain Kehinde Adegboyega, and I'm very sure for some of us that don't know me, I also want to mention that I lead the Human Rights Journalists Network Nigeria, which is part of the major convener of this West African Digital Rights Coalition. Very soon we'll make you aware of our website. We created a website for this coalition. We'll be sending more information about activities, what we intend to do. We're also open to ideas on whatever you think we can do to advance digital rights in West Africa and every country in the West African region. We'll be sharing more details on the WhatsApp group. For people that have not joined the WhatsApp group, you can reach out individually. Dr. Kimber, if you can drop your WhatsApp number on the chat now, so that people can reach out to you if you are not yet on the group. If there is any comment, the WhatsApp group is a very good way to reach out to us. And any other addition, anything that you want us to know, or any question you want us to answer that we have not been able to answer during this. Really want to appreciate you for your time, and thank you for joining us. And I hand over the ball back to Dr. Kimber. Thank you, Dr. Kimber, also for your time and effort.
Thank you, Honorable Convener. A big thank you, like you said, to Access Now, and also Article 19, and also baristas. They claim the nomenclature is changing. So I wanted to say baristas. I don't know if that's right. The Honorable Convener has appreciated everyone. And I think this is where we say we have a cutting call. We would have loved to have a group picture, but I noticed some people have started leaving. But if it is possible, if you're on a laptop, you could help us. Janet, this is where I have to call out to reach out to Janet. If Janet is there, could help out. Yes. So if you're on the laptop, you could help us out, take pictures.
So this is the time to let us see your beautiful face so that we can capture them. So if you think that you don't want to, if you want to share your videos, let's see your face, let's see your beautiful face. That's what we have been doing. Thank you. I think okay. Thank you, Dennis. Dennis is from Sudan. I may not know every other. Thank you, Janet, once again. Victor Ashante, Girayo, thank you, everyone. John, thank you. Matthew, I really want to appreciate the Article 19 team. Thank you, Devita. Oh, thank you, Madam Ellen. Oh, it's good to see your face. So at least when I see you at the airport, I can say, oh, this is Madam Ellen that was on the. Oh, thank you, Tamba. I hope I pronounced that word, Tamba. Is that pronounced very well? You can, so everybody can unmute your mic now, even if you have not been talking.
Yes, so, you can unmute. All ground rules suspended.
Let's hear your voice.
So, all ground rules suspended. I think
every other ground rules suspended. You can make
thank you very much. Thank you.
Kosi, I can't see your face. Dr. Kosi, if I'm not wrong.
Thank you.
Thank you. Thank you.
Yeah, we have your smiling.
As the pictures be taken, can we confirm if the pictures you are taking?
Thank you. Hi.
Hi,
and the word is Tamba. Tamba Tangbe. Did I get that? Tamba?
It's Tamba Tengbe.
Okay, Tamba
Tengbe. Tengbe.
Yes. Okay, has the picture be taken?
Yeah, I'm doing a phone capture, but if you're on a laptop, it will be very beautiful.
I'm on a computer, but I don't really know how I can do it. If someone could take me through.
Yes, there is this particular key that has the word PRTSC, which is print screen. Is beside F12, the F12 key.
Okay. Well, I'm using a MacBook. Is it the same? Does it work the same way?
I'm not sure. Me and Mark, we are not too friendly. They ate apple. They ate the apple. As a kid, we are told not to eat apple. Anyhow.
Okay, thank you.
On a MacBook, it is Command
I'm using my
3.
phone. If
On
all
a
of us
MacBook,
can.
you can use Command Shift 3. On a MacBook, you use
Oh,
Command Shift 3.
Command Shift 3.
Command Shift 3. So
Command Shift 3.
Okay, I got something, but I think we may have to arrange ourselves properly.
Yes, let's arrange ourselves. Please,
So
this is where you can put on your perfume. Your perfume will show.
Because what I'm getting here, the grade.
Yeah. So you will see once you screenshot, you see it on the bottom right.
Yeah, I tried and it worked, but then I'm talking about the arrangement.
I know it will take everything on your screen. That's all.
Really? So Command Shift 3. It came, but not everything came. I mean, it's just I just have 1, 2, 3, 4, 5, 6 people, and then nothing else.
Oh, okay, sorry. Let me go to.
I think the host has to let the view.
I think what I'm saying is that you can adjust for MacBook sometimes. If you need to take a screenshot, you need to like adjust. Once you type the Command Shift and the 3 and the F3, it will highlight where you want to take. So if it's not what you want, you can now expand it.
I've done it. I think it was from my view, so I'm going to do it. I'm going to do it now. So Command Shift 3. So can we all say cheese?
Today.
Yes, I've done it. So I'll send it to the WhatsApp group.
I hope you captured the smile from Eileen.
I'm really trying.
Thank you.
The best part of the webinar where we can take pictures, even though it's virtual.
Okay, so thank you all for coming. I'm sure we'll definitely meet again.
Because this meeting somewhere around West Africa.
Yes. So if most of you are coming to the FIFA Africa, I mean, I'll be in Dakar in the next month. Yeah, so we could meet and hang out or something. I'll be at
Dakar. We have a date in Dakar. We'll
definitely.
We'll talk about the food offline.
Okay.
Yeah. Please share the pictures on WhatsApp.
All right, I'll do that right away.
Yeah. It's been a great time.
Okay.
And we'll wait while we, have our socials. This is the best time to have your tea if you're, you drink tea. I'm a village boy. We don't drink tea in my village.
You eat Eba.
Thank you. But you shouldn't expose me, Dory. You shouldn't expose me.
No, you should ask him, is it cold about us Eba?
Okay, thank you all for coming.
Yeah.
We will definitely meet again. Okay, bye.
Yeah. See you soon.
All right, bye. I'll share the pictures on the page.
Thank you so much.
All right.
Oga Kosi, now you're online. Oh my Oga, my icon fellow. Oh.
How are you?
I'm fine. Well done, Kosi. Well done.
Nice to meet you again.
Same here. And I like your background. Is that the bridge to Nigeria or your side?
Okay.
I'll be closing the room. Thank you very much, everyone. Musa, Jimmy, Danaya, Dennis. Thank you so much. Have a nice day, everyone.